Recording in progress.
All right, good evening and welcome to the Tuesday, May 7th, 2024 Select Board meeting being recorded by Whitman Hanson Community Access Television. Please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. We are here regarding a hearing, a dangerous dog hearing, and subject to General Law, Chapter 140, 157, to determine whether a dog located at 22, which was located at 22 Ocean Avenue, Hanson, Mass, is dangerous, and we have served the individual in question with the fact that we were having a hearing subject to General Law, Chapter 140, 157, and we have given them the opportunity to appear on their own behalf with their attorney, call and question witnesses and present evidence, but I don't see anybody here but our dearly devoted Joe Kenny, our animal control officer, and remotely, I'm sorry, I'm not sure, it's Steve, I don't know. Chaplain, okay. With our town council. Mr. Kenny, do you mind taking our inquisition seat here, even though you're not really the party that's being...
Madam Chair, are you able to hear me?
Yes, yep.
If I may, I typically swear the witnesses before they give testimony. I'd be happy to do so this evening.
Oh, that would be great. Yes, if you would proceed. The only witness we have is Mr. Kenny, so that would be lovely. Yep.
Mr. Kenny, could you please raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now in hearing?
I do.
Thank you.
Okay, thank you very much, Mr. Chaplain. Okay, Mr. Kenny, what say you? Please tell us, we've got a report in front of us dated April 20th, 2024, which reads, on Saturday, April 20th, 2024, Patrolman Mario J. Thompson was on uniformed patrol working the 1600 to 000 hours shift. I was assigned to marked cruiser 496 working the south sector of the town of Hanson. At approximately 1908 hours, units were dispatched to 22 Ocean Ave for a dog bite. The calling party was a Mr. Bain Keefe, who is also the person who got attacked by the dog. Both Officer Ford and I arrived on scene shortly afterwards and was met by Mr. Keefe outside the residence. Mr. Keefe informed us that the dog was currently inside the residence. Both of Mr. Keefe's arms were covered in blood and had deep bite marks from the dog. Mr. Keefe's left upper chest area was bloody and had a deep bite mark from the dog. Sergeant Collegiero and Hanson Fire Department then arrived on scene, and Mr. Keefe was treated for the dog bites and transported to the South Shore Hospital. Before going to the hospital, Mr. Keefe granted permission to Sergeant Collegiero for us to enter the residence to remove the dog. Two of Mr. Keefe's sons were home while this occurred, a Mr. Talon Keefe and a Mr. Jet Keefe. Talon informed me that his brother Jet wanted to go to a friend's house, but Mr. Keefe told Jet no. A verbal agreement occurred between Mr. Keefe and Jet, and while they were arguing, the dog attacked Mr. Keefe, biting him on both arms and chest. All parties were informed to stay out of the residence, and the animal control officer was contacted and arrived on scene. The animal control officer entered the residence and removed the dog. While removing the dog was located in the corner of the living room covered in blood. The dog looked scared as though it was going to be beaten. The dog was retrieved by the ACO and transported to a shelter in Lakeville. At this time, there is nothing further to report, and that's signed Patrolman Mario J. Thompson, Hanson Police Department. We now have the the call was placed, you come to the residence and let us know what you saw.
I arrived,
Yeah.
it was 22 Ocean Ave, arrived there. It's been an ongoing issue between them and who owns the dog, between Mr. O'Keefe and Mrs. O'Keefe. They have the dog living in Hanson and haven't quite figured out paperwork to see who signs the dog over. They've had issues with the dog being aggressive in the house before.
Oh, okay.
And because of it, they wanted the dog placed outside of the house. I informed them the process for that would be for us to take it. It would be the responsibility of the owner to find placement or make a decision on the dog's welfare. And when I arrived there, it was pretty bloody and messy. The dog was located in the house. Family members are outdoors. Mr. O'Keefe had been transported out of there, so I picked up the dog. The dog was originally in the front of the house and kind of made its way toward the back of the house. We were able to kind of force it and corner it into a corner, and that's where the police probably saw it.
And was it being reactive to you?
It was being pretty reactive to me.
Yeah.
It's since been placed in Lakeville and spoken with the Lakeville Animal Control, and it's been fairly reactive to him as well. He's told me that he doesn't feel comfortable adopting it out. It would be a liability on the shelter.
Yeah.
And it still remains placed there. We don't have true ownership of the dog. It hasn't been signed over or anything. So.
Do we know who actually has ownership? Because I think there was some question about it not being registered with the town and...
Yeah, so
okay.
Going back farther, I believe the last time the dog was registered, it was registered to Mrs. O'Keefe as opposed to Mr. O'Keefe, and since then it's kind of wishy-washy. I think they got the dog together, and that's kind of where they're drawing lines.
And you've spoken to both parties?
As far as paperwork, yes.
Yeah.
And as far as paperwork goes, vet paperwork, license paperwork is all under Mrs. O'Keefe.
And you've spoken to Mrs. Keefe, but she resides in Rockland and not in Hanson. And you've spoken to her, and she is not...
She's unable to take it. She's
okay.
Living in a situation where she can't have the dog.
Okay.
Location.
And of course, Mr. Keefe with the children and with this past situation. And my understanding is that are there any rescues that would take a dog like this?
So, in my opinion, I personally wouldn't adopt it out. I think it would be a difficult dog to place. Most dogs have to undergo a behavioral test.
Yes.
How old is this dog?
This dog is,
good question.
I think it's 6, if I remember
Oh.
correctly. And it's an Australian Shepherd. It's, in my opinion, if the dog was signed over, this wouldn't be a matter for the board. It would be a matter for the dog to be made a decision by the family.
Right.
But unfortunately, we're in the situation we're in right now.
We don't have anybody taking ownership. So in the absence of anybody else taking ownership, it's the town's responsibility because it happened in the town. Mr. Chaplin, is that true?
I'm not sure I understand the question, and only because some of the audio is a little muffled.
Sure, no problem. In the absence of either party taking ownership and responsibility, does it fall to the town to make the decision what to do with this dog?
In terms of, I think it might be a sort of a compound question. So the nature of the proceedings tonight is that there was an attack.
Yep.
And when there's an attack and the board receives a complaint about the attack, which we've effectually received from the animal control officer, the statute requires that the board investigate the complaint to see what happened. And so before you this evening, you have the police report, you have the animal control officer testifying in person, and there's nobody testifying in opposition. So it's pretty clear there was an incident here where there was a vicious attack. What the statute then requires the board to do is it requires the board to make a finding.
Okay.
The finding can be either that the dog is a nuisance dog, and I can instruct the board on what the meaning of that is. That the dog is a dangerous dog, that's another statutory definition that I can instruct the board on. Or that the dog is neither a dangerous dog nor a nuisance dog.
Okay, so we have, unfortunately, the board, and I don't recall any recent boards having this many hearings, dog hearings, but we have had hearings. But do you mind recapping for us the criteria for dangerous versus nuisance, just for a refresher?
Absolutely, absolutely. So the definitions are actually set forth in a different statute than the one you would have read. So not to worry that you didn't see that. It actually would not have been in front of you. The definitions are in Chapter 140. They're in Section 136A. So there's three ways that a dog can be considered a nuisance dog. The first way is by excessive barking or other disturbance. It is a source of annoyance to a sick person residing in the vicinity. I don't think that's applicable in this case. The second way that a dog can be a nuisance dog is that by excessive barking, it causes damage or other interference a reasonable person would find such behavior disruptive to one's quiet and peaceful enjoyment. And the third way a dog can be a nuisance dog is that it has threatened or attacked livestock, a domestic animal, or a person, but such threat or attack was not a grossly disproportionate reaction under the circumstances.
Okay.
So from a legal standpoint, to the extent that the board might be considering calling this dog a nuisance dog, the real issue, there was obviously an attack to a person. In theory, the board could find that the attack was not grossly disproportionate under the circumstances. In contrast to a nuisance dog, a dangerous dog, there's two ways we can get there. The first way is, without justification, the dog attacks a person or domestic animal, causing physical injury or death. The second way is, a dog behaves in a manner that a reasonable person would believe poses an unjustified imminent threat of physical injury or death to a person or to a domestic animal.
Okay, all right, so, it does appear that this would rise to the level of dangerousness and not a mere nuisance. And you know, I know this is a bit of a loaded question. You had indicated there was a history here with this dog attacking people. Like, can you remember how far back it went?
It goes back probably close to a year. I wouldn't have the exact dates in front of me.
Okay.
It would go back probably close to a year, and it's come from residents of the house. So it's come from mostly Mr. O'Keefe. I'm sorry, I keep saying O'Keefe. And saying that the dog is aggressive and he wants it taken out of the house. Unfortunately, we can't just take a dog out of the house. We don't have a kennel or a place to impound them. So we don't take surrenders. I recommended that he reached out to a handful of different rescue groups, or that if it's too aggressive and they can't place it that way, that they set up an appointment with their veterinarian and talk to them about other options. I also talked to him because he was concerned about the legality of whose dog it was. I talked to him about how to go to the courthouse and get papers filed to make sure that the dog's in the right name. If the dog's going to be living with him, he's worried about that.
Okay.
As far as I'm aware, nothing had come of that, and there's nothing about this situation.
Okay. So your recommendation to us, Mr. Kenny, is?
So it's kind of a complicated situation because the reality of this is it's inside of a house. It's inside of one home. The responsibility of this falls on the dog owners. And where the dog resides and who they falls on their own decisions. Had Mr. O'Keefe or Millman requested this hearing, I would probably be singing a different tune. But in this case, I think it's a situation where the owners are kind of not taking responsibility, and we're kind of left to pick up the pieces here. And without having the dog under custody of someone, then we can't really do too much other than a hearing in this case.
Now, one of the criteria that Mr. Chaplin read was unprovoked, that it was an unprovoked attack. Do we have a sense on whether this was an
In most of these cases, you'd have two parties going back and forth. Party A would say, that dog bit me, I was doing this, and they would say, no, my dog did this, and that's why it bit you. In this situation, we don't have that, so it's really just going on a situation, and the outcome of it was. I was asked to remove the dog by the police because it was unsafe to have in a house with young kids. So in this case, I feel as though it's probably not a safe situation at the house to have the dog in the house.
Okay.
How old are the kids? Because that was my
Yeah,
question.
good question.
I do not know the ages of the kids.
Could you
They're
just ballpark it?
Teenage.
Teenagers?
Yeah.
Okay.
Young
Yep.
teenagers.
Young teenagers?
Yeah.
Yeah.
Madam Chair, may I?
Yes.
Chair, very briefly. There are two exceptions to a dog, where a dog attacks, where a dog it can't be deemed dangerous. And I just want to make sure we don't overlook this. If the dog is deemed to be protecting or defending itself, or a person from an attack or an assault, or if the person who was attacked was committing a crime, then the dog's attack would render the dog a dangerous dog. I'm not entirely clear on what the dynamics are here, but I just want to make sure we turn those stones.
No, that's a fair point. I think, unfortunately, it's a fair point. Unfortunately, none of us were in the home at the time.
But
Mrs. Rain.
in the report, it says that there had been a fight between one of the boys and the father. So he could have been...
They pick up on energy.
Yeah, of course he does.
Yeah.
Of course he does. So he could have picked up on that energy and went after the father.
So I know we're here for a dog hearing on the trying to designate dangerousness, but so tell me if this is out of line for asking this question, but I guess I'm kind of hung up on the ownership piece. Are there laws or enforcement options that we have as a board to try to figure out how to sort through ownership so that the actual owners can be identified and they can be handled through the proper channels versus it's really hard to make a decision when only one side can talk,
Well, no side, really.
No sides to talk.
No sides talk.
Well, we have a
Just
report.
the reports, yeah.
So,
I could try to help answer that question, but one quick follow-up I would have for the animal control officer is, do we know where Ms. Keith lives? And if so, is that within the town?
It is not within the town, it's in town of Rockland.
It's in the adjacent town, and she was served with a notice of the hearing as well.
Okay. Because what the statute tells us is if you deem the dog a nuisance dog, you have to order some type of remedial measure. But if it's a nuisance dog, the statute doesn't tell you what that is. It leaves it wide open. If you deem the dog dangerous, the statute gives you 7 options. When I say to choose between, you can order one or you can order more, but you have to order at least one. The most extreme is to have the dog put down. The other options are to order that the owner install a dog run, take out an insurance policy, confine the dog, muzzle the dog, walk the dog on a leash of a certain length and certain tether. One thing the statute does say is that the hearing authority, in this case your board, cannot order that the dog be removed from the community. So in a way, I know this is a frustrating answer, but sometimes the bearer of bad or frustrating news. It's almost like our hands are tied a little bit. This keep is outside of the community because legally, this board can't make an order that the dog go with her. It's actually, I do a lot of these hearings in person. I've encountered this particular issue. Really, you have a situation here where Mr. Keefe is the keeper of the dog, and he's saying to the town, I don't want to be the keeper of the dog. We can't make that order. The board could order Mr. Keefe to confine the dog, to muzzle it, to walk it on a certain type of leash, to take out an insurance policy, but the board could order that the dog be put down. And then if the owner wants to come forward and challenge that, they can. But this is a pretty difficult situation due to the practicalities. And I just wanted to get all of that legal framework out on the table.
No, that's helpful. That's very helpful.
So where the Mr. Keefe seems to not want the dog in the home or take ownership of the dog, and the dog is out of the home right now, could we even force somebody who's not claiming ownership to even take the dog back?
What are we going to do, drop it off?
Because just like we can't, logically, and I'm probably wrong on this, but just logically I'm thinking, if we can't order something for somebody outside of the town, we also can't order somebody that doesn't claim ownership of something either, right?
It's a tricky point, but I think the answer to that is no, because the statute talks about the owner or the keeper of a dog, and those are not necessarily the same. Mm-hmm. I could have legal, because a dog, I know we often regard pets, especially dogs, as members of our family, but in the eyes of the law, a dog is property. Mm-hmm. So if I'm the legal owner of a dog, that might be what it says on the paperwork, or who it's licensed to. But that dog could be staying down the street or in another town with my cousin, my friends, parent, child, what have you. That person is the keeper of the dog. And the statute gives the hearing authority, this board, authority over an owner, but also over a keeper. So this is a situation where you've got Mr. Keeper of the dog, and I understand there's a family issue there where it sounds like he doesn't want to be the keeper of the dog.
Right.
But we do have authority over him. Unfortunately, this board could tell him to confine the dog to his home. But I understand the practical question where you're saying, well, it's we have custody of it right now. What are we going to do? Drop it off at his house?
I guess that's my point. Yeah. So because he's not claiming ownership or guardianship of this, and how are we going to force him to take it back when he didn't want it in the first place? It seems like there's a year-long history of him saying, "Please get this dog away from me," and there's nothing we can do. So now that it's out, can we force him to take it back?
And if we do force him to take it back, is that the right thing? He's got two young kids in the house, and it's already attacked on a couple of different occasions. And I mean, this time, it sounded pretty brutal.
Yeah, I think that speaks to whatever order we're going to make, but I'm just trying to sort out first what,
That's right. So I think if we go by the letter of the statute, and, I sit on the municipal court too, so if I were in your shoes right now, I'd be saying, okay, the letter of the statute isn't necessarily practical. So, I'm dealing in a three-dimensional world. The two-dimensional pages may be helpful, but maybe not in this case. But if we just go by the letter of what's on the page, we have 7 options to choose from, and 6 of them contemplate us forcing this gentleman to take the dog back. In theory, we could do that. How do we execute it? It's probably a conversation, with the police department on the side. But you have 6 options that contemplate doing that, and you have a 7th option that doesn't. But that 7th option is not sending it back to the owner who's missing in action, and it's not the town continuing to be responsible for this dog. It's really not its responsibility. That option is to put the dog down, and it's the most severe.
Do you believe that
effort to help the board sort this out? I think that's kind of what you're faced with.
Do you believe that both parties understand that this dog may potentially be euthanized because nobody is stepping up to take responsibility?
I think they probably do understand. It's been a topic that I've talked to both sides of this party with. I think it's just neither side taking full responsibility for the dog.
It's probably one piece of a very complicated
Which,
situation.
yes,
so,
and
yeah.
I'm assuming.
I'm sure, looking at it, it seems like there's all kinds of moving pieces. I
Yes.
see 2 young children, or teenage children, and then 2 adults who are breaking up. And the dog seems to be more, from what I'm hearing, the children want the dog more than the adults. And the adults not being here seem like they want to put the responsibility of telling the children we have to put the dog down. They're taking it off their plate and putting it on ours.
Well, you make a good point, Mr. Hill. I think not being present at a hearing about a dog speaks volumes about the level of engagement with the welfare of that animal, going forward. So, okay. Mrs. Rain, did you have any other questions for counsel or for Mr. Kenny?
It's a lousy situation, but I don't see how it gets resolved by any way but the 7th option.
For the record, Madam Chair,
Yep.
just to comply with the law, the board will have to first make a finding whether Cooper is a dangerous dog.
Oh, yes.
Dog,
Yep.
or
Yep.
neither. And then, depending upon what the board finds, they'll have to take a second vote as to what remedial measures will be required.
Understood. I just want to make sure we're wrapping up on Q&A right now, and then we'll move to the vote. Yep. Mr. Weeks, did you have any questions for counsel or for Mr. Kenny?
No, it's just a comment. Just, it really it really is sickening to me right now, because it is we call it in my field, a diffusion of responsibility. And this is a decision. I love dogs. I love animals in general. And this is a very finite decision. And this is the first time I've ever had to make a decision like this, and it's actually kind of gut-wrenching, to be honest.
Yeah, I feel queasy. It doesn't sit right. Mr. Hill?
Yeah, I feel exactly the same, but I have a question about like the 2-step process, the dangerousness, and then what we do next. Like, do we?
Well, so is it generally conceded that we think that this dog rises to the level of being declared dangerous versus nuisance?
Yeah.
Okay, so I will entertain a motion to declare. I don't know what the heck
To say it's dangerous.
Cooper
Optional.
as a dangerous dog under the statute. Do I have a second?
Second.
Okay. Wait a minute.
Who made
Did
the
somebody?
motion? I didn't. No,
I was going to say.
I didn't make the motion.
No, I said I will entertain a motion.
will,
Then
if you want a second.
Then you
I'll make
seconded it.
a motion to determine the dog is a dangerous dog as defined by
Okay,
the law.
and is there a second?
And I will second that.
Okay, thank you for getting us procedurally
Great-
correct there.
great report.
All in favor? Do we need to do a roll call on this, Mr.
We
Chaplin?
may need to, because I don't agree with
Technically,
that.
I'm the only one who's remote, and the board members are all present. That said, a roll call would not hurt.
To be clear, we're not saying what we're going to do in this motion. That's the
Correct.
second part.
Right, but the
Okay.
dangerousness, for me to understand, can I ask a question before we?
Yep,
finish?
yep.
The dangerousness is unprovoked, and I have a problem with that word, the unprovoked. That if there was a fight going on in the house at the time, a dispute of some type, and the dog felt it was protecting the child from the father, I don't think that's unprovoked.
Got a good point.
Well, that's why I asked that question earlier, but we don't know.
We don't know.
The thing is, this kills me to say this because I'm going to sound like I'm talking out both sides of the mouth. If the police are involved, if that was the case, there would have been a 51A that would have supported something like that, because it's not like the investigation just ends because of one particular
So
thing.
for the uninitiated, 51A is...
No,
No, no,
it's another
no,
layer of
no,
like,
I'm saying people might not know what 51A refers to.
I understand. No, I
Yeah,
get that.
yeah.
It's a call to DCF about child abuse and neglect in
Yeah,
that moment.
yeah.
So if that was just because there isn't one doesn't mean that wasn't the case either. So I don't want to make it seem, but it's just, there's a lot of conjecture about like what we think could be happening when the police
We have to
report
base it on the
specifically
facts
says
we have. Yep.
what happened.
Yep, yep.
That is a good point. I will say I used to work in the family sphere, and an incidence of violence in proximity to a child would be something that would trigger the filing of a 51A. 51A is just the report. It tends to be over-reporting in my experience, and then 51B is the investigation. So sometimes the 51As get screened out, sometimes they're not supported, sometimes they're supported. But it is a good point that we're not aware of that happening, and I don't believe it's noted in the police report.
It is not.
No. And then there's other mandated options that could have come if it was, and again, I'm just throwing all the options out there because there's a bunch of options going out. So there would have been like a sectioning protocol to if there was abuse or some type of other thing where someone needed to get removed because of aggression. None of that's indicated in the police report.
No, it isn't, and we have to deal with the facts that are before us. So we can't, even though we may have a very strong thought about what potentially might have happened, we don't know, and we have to make the decision based on what we have in front of us. Okay, so we were taking a vote. The motion had been moved and seconded to declare Cooper a dangerous dog, and I don't know that we actually moved to the vote because then you started asking us questions. So we'll move to the vote, and to the extent that you are a no, then you just don't vote yes, okay? And then we'll say all those opposed. Okay, all those in favor? And I can't even emphasize with regret. And all those opposed. Okay. Okay, then that brings us to making a decision based on the declaration of the dangerousness. And Mr. Chaplin, do you mind reading the 7 options that we have before us?
Not at all. For the record, just for my notes, what was the vote on the
3-1. 3 in favor of declaring it dangerous and 1 opposed.
3-1.
Yep.
Absolutely. So the 7 options after a finding of dangerousness are 1, that the dog be humanely restrained, provided that no order shall provide that a dog deemed dangerous be chained, tethered, or otherwise tied to an inanimate object, including but not limited to a tree, post, or building. Number 2, that the dog be confined to the premises of the keeper of the dog, provided that confined shall mean securely confined indoors or confined outdoors in a securely enclosed and locked pen or dog run area upon the premises of the owner or keeper, provided further that such pen or dog run shall have a secure roof. If the enclosure has no floor, it shall be secured to the sides. The sides shall be embedded into the ground for not less than 2 feet. And provided further that within the confines of such pen or dog run, a doghouse or proper shelter from the elements shall be provided to protect the dog. Option 3. When removed from the premises of the owner or the premises of the person keeping the dog shall be securely and humanely muzzled and restrained with a chain or other tethering device having a minimum tensile strength of 300 pounds and not exceeding 3 feet in length. Option 4, that the owner or keeper of the dog provide proof of insurance in an amount not less than $100,000, insuring the owner or keeper against any claim, loss, damage, or injury to persons, domestic animals, or property resulting from the acts, whether intentional or unintentional, of the dog, or proof that reasonable efforts were made to obtain such insurance if a policy has not been issued. Provided, however, that if a policy of insurance has been issued, the owner or keeper shall produce such policy upon request of the hearing authority or a justice of the district court, and provided further that if a policy has not been issued, the owner or keeper shall produce proof of efforts to obtain such insurance. Option 5. That the owner or keeper of the dog provide to the licensing authority or animal control officer or other entity identified in the order information by which a dog may be identified throughout its lifetime, including but not limited to photographs, videos, veterinary examination, tattooing or microchip implantations, or a combination of any such methods of identification. Option 6. that unless an owner or keeper of the dog provides evidence that a veterinarian is of the opinion the dog is unfit for alterations because of a medical condition, the owner or keeper of the dog shall cause the dog to be altered so that the dog shall not be reproductively intact. Or, option 7, that the dog be humanely euthanized.
Okay, so this gets to the point that Mr. Weeks was mentioning, which is we can't, you know, as you were reading the piece about insurance, it occurred to me that at this point, Mr. Keefe is the only party that has been physically injured. If this dog is prone to this type of behavior, and we just declared it dangerous, so it's possible that it could turn to the children. It's possible it could turn to a complete stranger. And I don't think that dumping this dog back off at this residence is going to achieve anything because they have already indicated that there's an unwillingness to engage. You know, for instance, if this has been happening over the last year, most people that have a dog that are taking responsibility for it would probably have sought some professional help from a trainer to try to nip it in the bud as soon as you possibly can so that it doesn't exacerbate. It never gets cheaper or easier with animals to try to change behaviors. So I think the failure to do that, the fact that nobody has picked this poor little guy up from, the pound, I think speaks volumes, the fact that nobody wants to own it. So I don't think we really have options 1 through 6 on the table. I just don't, which leaves us with option 7, which is euthanizing this dog. And I just have to say, and I know you guys feel the same way, I assume you do, I don't know what led this dog to this point in its life where it felt like it needed to attack an adult man. But something really jumped the track, and I feel bad that this poor animal is going to suffer as a result of that. Well, it's suffering now because it's in the pound, it's, not leading a normal life, it's being aggressive towards somebody who deals with dogs all the time. So, there's the chances of rehabilitation, and again, who would take ownership of the dog to rehabilitate it, they're not even on the table. Mr. Heel, thoughts? Well, you already voted against dangerousness, so.
Right, but I agree that the 1 through 6 are really off the table because all of those imply the owner is going to take responsibility and wants to keep the dog. Right. And basically, there's no evidence of that, so.
Okay.
Unfortunately, with the dangerousness, that's why I was asking about the order. If we did the one vote, then if the only other option, if you do dangerousness, and the first 6 are off the table, and it's got to be euthanization, the vote of the first vote really led to the second vote being forced on us.
Right.
My questions are, I'm just looking at it from the perspective of, I just want to ask a couple more questions because I want to dedicate a lot of time to this because this is a very finite decision and it deserves that respect. So just bear with me on this. Is there any legislation, anything that we can do that, because people are going to watch this between now and whenever, and you might have somebody in the last minute, because I know you said that you didn't feel comfortable with the idea of fostering it out in in where it is now, same thing, shows a lot of the behaviors. If somebody watches this and says, I do dog rehabilitation, I can handle this, is there any wiggle room that we can give this a second chance? Is there anything at all we can do and say, if you're going to take the dog, then these are the various orders because we had to do that? Like, is there anything that we can do to save this?
Well, we don't own the dog, so.
Well, that's why I'm asking.
Yeah.
We don't own it. That's why I'm asking.
The dog signed over to the town.
There's 2 answers to that. One is that the decision in this matter is subject to an appeal to the district court. So the owner could, so this is answer number 1. The owner could appeal and that's technically litigation. We could resolve that if the owners came forward and said, we'd like to resolve the case on next terms, that if that was someone who rehabilitates and rescues dogs wanted to take it to the board, we could have a proposed agreement on the table. We could enter into an executive session, just the board and myself, and the board could elect to accept that as a settlement of an appeal. That's one way to do it. Another way, if someone came forward, this would be very unusual. I've never seen it done, and I'm not suggesting that the board should do this. But if someone came forward and said, board, you are the hearing authority, and we now, since you've rendered your decision, the facts have changed insofar as there's a person who rehabilitates dogs who is ready, willing, and able to take this dog and would like to do so, but we would need you, the board, to modify your order, so we're going to ask for a modification. The statute doesn't contemplate that, but in the court world where I've spent the last 10 years of my life, that concept exists virtually across the board, no matter what kind of proceeding you're in. Even if you have a result at a trial, there's a post-trial motion for reconsideration. Just about every forum where you come to the court and say, court, I know this was the result that was reached, but since that result was reached, we have newly discovered evidence, or we have a change in the law, or we have something that wasn't in front of the decision-making authority that we believe changes the calculus, if you will, and would warrant a different outcome. So there's nothing in the statute that says you can do that. There's nothing in the statute that says you cannot do that. My view is that if the statute doesn't say it, it leaves it to us to fill in the blanks. And I would be perfectly comfortable, writing a decision of modification or reconsideration if someone were to come forward and the board were to want to do that. And I've never seen it done, but I think it is something that could be done.
If we did vote to euthanize the dog, how long does it take? Is there a waiting period? How long does that take? Just to Mr. Weeks' point, in case something suddenly changes and somebody in Mrs. Keefe's life and she's able to take the dog, how long is it before that would go into effect?
There's a 10-day appeal period for an owner or a keeper to appeal to district court. Then there's going to be the issue, this has been weighing on my mind as we're talking about this, the order is that the owner or the keeper euthanize the dog. Now the owner or the keeper is probably not going to want to do that. I'm not sure what the situation is here, and obviously neither are you, because those folks aren't here to tell us what the situation is. If the situation is, it's a hard decision and they would rather that the board make it than them because of family dynamics, but in the end they would agree to euthanize as long as they weren't the ones who had to make the call. But if that's what the situation is, then we can work with them to do that. But if they continue to not cooperate with us, my recommendation to the town would be, we're in possession of somebody's property and we have ordered them to euthanize, but I would recommend that we go to court and seek affirmance from a judge giving us the authority to euthanize.
And would you suggest that we make that, we take that vote this evening on top of the youth, that we do a 1-2 transfer, ownership to the town, and then enter into the order to euthanize, or just stick with the dangerousness hearing and the order to euthanize tonight, and then I don't know when we would take up the transfer of ownership.
So that's correct. The statute, unfortunately, does not give the board the power to transfer ownership. It only gives the board the power to investigate, determine dangerousness, and to impose sanctions. The statute contemplates, and that's why this particular case is unusual, the statute contemplates an owner that's engaged in the process. And we're stuck with a difficult situation here because the owner's not present. So I have had situations where the owner is present at the initial hearing, then they appeal, and then we if they don't comply with the order, we have to chase them, which we typically do in courts. There's another avenue potentially too, because it's actually, I don't think it is available here, because to keep a dog in violation of an order is a crime, so we could potentially seek a warrant through the criminal side of the district court. But here, where the dog is not being kept by an individual, we really can't charge him with a crime. So I think the only way to do it, and it's cumbersome and it's imperfect, and if I were sitting in your shoes, I wouldn't like it one bit. But the only way I see to do it legally is you made the finding of dangerousness, if you order euthanasia, wait the 10-day appeal period. If the owners engage, then we can work it out by engaging with them. But if they don't engage, then after the 10 days runs, I suggest that we run into court, and it would be the type of thing where no judge is going to want to order this without both parties at least having an opportunity to be present, which I understand is frustrating because there was an opportunity to be present tonight and it was not taken advantage of. But just knowing the way that the courts work, it's going to be the kind of thing where we run in, we ask for a date on short notice, hopefully we get it, so it will probably be a 1 to 2 week turnaround before we have a judge bless it and tell us that we can go ahead and do the euthanization and pursue the owner for the costs.
Okay, so there is some, it's not like it's tomorrow this dog is going to be euthanized. There's some, ability to appeal, communicate, and this essentially puts the folks on notice that this is the direction that we're heading in if there's no intervention on their part.
That's absolutely correct.
Okay.
Feel better about that, because it's...
I feel a little better that there's an ability for them to appeal and that it's not, but there's nothing that anybody could say that's going to make me feel good about this. Okay, I will entertain a motion to euthanize Cooper.
So moved.
Second.
I mean, I want to say all in favor, but, okay, all in favor? All right. And were you, your yes?
No.
Well, you're a no, okay, okay. All opposed? Okay. I mean, in reality, Mr. Heel, we're all opposed, but
I know.
we have to do what we've got to do.
I'm 50-50 to say yes because of what was just...
Okay, so that was a 3-1 vote, again, Mr. Chaplin.
Thank you.
Okay, and is there anything else that we need to do? Are we able to adjourn at this juncture?
You were able to close the hearing.
Okay, great. So I will entertain a motion to close the hearing.
So moved.
Second.
All in favor? I will entertain a motion to adjourn the meeting.
So moved.
Second.
All in favor? All right. Thank you very much,
Thanks for the
Mr. Kenny,
guidance.
and thank you very much, Mr.
Thank you very
Chaplin.
much.
I appreciate it. It's tough. It's really tough.
It's not fun.